Yeah, what I'll tell you is a lot of people come in with a very simplistic view of, well, yeah, he was my dad. I should get everything.
Hmm.
Pretty simple, right? Well, if he didn't leave a will, it gets a little bit more complicated. And so people have a hard time sometimes understanding that it's not as simple of well, I was the child, I was the one he loved the most, or that they loved the most, so
Right.
I should get the most. Well, if it's not written down in a will, that's not going to happen. And then on top of that, you're going to be fighting with all of your kin to get a share. I can give you an example of one I did. Uh, this gentleman had a rather large estate, and my client had a couple siblings, and this was an uncle. And what had happened was that the whole thought process was that he was only going to give the money to her sister because supposedly the way the family dynamic was, that's the way it was going to happen. Well, it turns out that when he died, there was no will. Uh,
Yeah.
no one could provide a signed copy of a will. So at that point, what we began to fight over was okay, if there's no will, then that means it has to go according to state statute for intestate uh, estates. And that would have meant, yeah, what it came down to, it was just my client and her sister, so that they would have been
Mm.
splitting a rather large fortune. Uh, and as in most cases with the law, again, I already mentioned this can take some time to,
Right.
kind of go through it. Uh, After a little bit of going back and forth and, not making a lot of progress as far as the clients were concerned, suddenly everybody decided to talk and compromise, and we managed to get everything settled. So that's just an example of what you can do. I've got a couple of others. Yeah,
Yeah.
they're not going to settle. They're going to end up going to court. So yeah, it's going to be contested, and yeah, in my view, it doesn't have to be. But I will tell you that no one plans on dying, and they always plan on I'll be able to get to it. But
Uh,
you know,
hmm.
when death intervenes, that's it.
You are right. And you talked a little bit about going to court and litigation. That's also a question that comes up a lot in our Facebook community. Um, do if you have a family like the one you described where litigation is an option, how do you help the family decide whether litigation is their best option or if they should look at other alternatives?
Well, the thing you do is initially in all these cases, everybody's very polarized. So, you
Mm.
know, I have my truth and they have their truth, and the two just are not compatible. What you have to go through, that there will be a number of steps. It's not all one big trial. Sometime in the future, what you're going to find is that with the courts, there's going to be little trials here and there. There's going to be challenges to what you think your truth is. Well, depending upon how those cases can come out, it can begin, the realization will begin to set in that my truth may not be as solid as I thought
Mm.
it was.
Hmm.
Uh, I don't know if I want to risk going all the way down this path to trial.
Yeah.
I'd be willing to compromise. And that's where people begin to talk. And suddenly, yeah, you can reach a compromise. And while no one is totally happy, they know it's a better solution than going all the way to trial, because what their lawyers will tell them is, well, if you take this all the way based upon these set of facts, yeah, you're probably going to get you know less than what you're thinking.
Hmm.
So
Hmm.
yeah, it's an interesting process, but it does take time.
And are when you're working with a personal representative and someone in their family wants to challenge them or contest and it looks like it's going to litigation, um, do you end up do they typically always have their own, does the family member who's challenging typically have their own attorney, or are there cases where you might get involved and help mediate the dispute between two family members or multiple family members.
Well, it always depends.
Yeah.
Sometimes you'll get a family member that thinks they know the law.
Mm-hmm.
It to them it should be it's really simple. I mean, just think about it, and
Yeah.
you'll see my way is the correct way. Fortunately, it doesn't work that way. Others will go out and get attorneys, and then we'll do the battles back and forth as to what's going to happen. Uh, yes, and the thing about a contested probate, I've already told you probate can take a while just because of the legal steps. But if you go in and you've got a contested probate, you have totally locked up that estate,
Mm-hmm.
which means if you got property, you can't sell it. If you got a bank account, you can't access it. If you got pension funds or investments, you can't get at them. And this can be a real hardship sometimes on the estate because the estate still may have bills it's got to pay.
Right,
Uh,
right.
and so that's another factor that weighs heavily whenever you start thinking about, okay, is there a compromise to be reached here?
Mm-hmm.
So, as I say, there are a number of factors that will play in to this process, and at each point along the way, there could be a new determination of what people want to do. So you're always uncovering new facts and new things will come into play. And so it's a very dynamic process.
Absolutely. And you talked a little bit about the estate of Prince, the musician in Chanhassen. You're also in Chanhassen City Council, so you were very familiar. One of the questions that came in from our Facebook community is they're like, the question is it beneficial to file for probate before other family members in an intestate estate file to become administrator? So someone died, there's no will, and there's multiple heirs, kind of like in the Prince situation.
Yeah. Well, it's advantageous from the standpoint of, okay, at least we're going to get it in court.
Mm-hmm.
Um, the person that files is usually wanting to be the personal representative to the estate. Well, if it's contested, and the way probate works is you file a petition and you go through all the particulars of who the personal representative is, their name and address, relationship to the deceased, all the deceased information, date of birth, date of death. You attach the death certificate. Then you go through and you have to say who are the next of kin,
Mm-hmm.
and you have to list everybody out. They're known as interested persons.
Okay.
All of those interested persons have to be notified that you've started a probate. Uh, if they decide they're going to protest it, then what they do is either they'll get a lawyer or they'll go in and they file as an objector. And so now we have an object, a probate controversy,
Mm-hmm.
and that changes everything. So now that what the court will do is we'll start scheduling hearings, to begin to look at, okay, why are you objecting? What's the grounds for that? Uh, do the attorneys need to talk? Do we need additional evidence? Do you have to go out and get experts? An example may be that someone doesn't agree with the value of, say, an asset, and think that well, you're undervaluing it so you can get it at a cheaper price, and I don't think that's right. So
Mm-hmm.
maybe you have to get an appraiser specialized. I had one case where the individual collected toy farm tractors, and
Mm-hmm.
there is a big market, or there used to be big markets in all these collectibles. Uh, he had a lot of, I mean, hundreds, and everyone was different, and everyone meant something, and everybody assigned a very high value to all of these tractors, and so yeah, the big fight was over what's the value of the estate.
Mhm.
Well, again, you go out and you try to get an appraisal, and that's not that easy to do.
Yes,
There
absolutely.
really, yeah, there really isn't anybody out there appraising toy tractors. What they're
Hmm.
worth is what you can sell them on eBay.
Yep.
So what you have to do is you go out there and you try to find similar items that have sold on eBay, and now you begin to attach that as the value. Uh, I mean, I had another case where we had baseball cards from the 50s. So you would think, oh, those are really, really expensive. Well, again, I had to go through the same process because at that time there was no market for baseball cards.
Right.
That was during the period where kids were no longer collecting them. It was the baby boomers that had them. And so there was no market, and had to do the same thing. Take them out to eBay, and there's a marketplace for that, and you get what you get.
Hmm.
So those are things that you kind of fight over, and those are the things you have to. How are we going to achieve the objective? And that's where you got to think outside the box, and that's not an engineering solution.
That is so true, and we run into that situation on the real estate side as well, where there, even if we can get an appraisal, there's still the emotional value and the perceived value, and
Yeah. Okay, your sound just cut off.
are we back?
Yep, you're back.
Okay, thank you. When you were telling the story about the tractors, I was thinking about when my father passed away, and he had different collections that had a lot of sentimental value and not necessarily a marketable value. And some people in our family spent a lot of time. Um, and initially there was some contesting of some of these things, and then people spent a lot of time trying to sell these things, and
Yeah.
it's it's hard. It's really hard. So that's great that you take that into consideration and help guide families through that. Is is your ability to do that also partially because your practice is really focused on that personal service? I know there's some large law firms
Yeah.
can't always or maybe don't deliver that same kind of personal service.
Well, yeah, I try to stay close to my clients, and again, I try to guide them through this. The thing is, people will come to you with preconceived notions of either the value of something or their right to something.
Hmm.
And I don't just confront them with, no, that's not reality. It's like, okay, how do we validate what your thoughts are?
Right.
What's that going to take? So you lay all of that out for them, and they can make a decision at that point, and I try to help guide them through it. But uh, at the end of the day, they have to make the decision as to what they want to do. If they want to fight it in court, I'm fine with doing that. We'll go ahead and fight. But yeah, I try to make sure they have all the knowledge on their sides so they have an idea of a more likely outcome
Hmm.
as to what is going to happen at the end of the day. Uh, so yeah, I do a lot of hand holding and try to walk people through it. And again, the biggest thing I see is people are still dealing with grief. I mean,
Right.
if you're in probate, it's because somebody died, and some people, well, as you know, you probably see it all the time. People process grief differently.
Right.
And some people will start a fight in probate. That's their way. That's their way of
Hmm.
getting through the grief of the whole situation. And as an attorney, you got to be kind of attuned to that, because if you can, now you can approach it a little bit differently, and maybe reach a settlement that'll make everybody happy. Whereas if we proceed down this path, even if I win, they're not going to be happy because you haven't settled what
Right.
the problem is.
Right.
So yeah, it's a again, it's not a black and white solution that you follow the numbers. It's a little bit of nuance that, okay, we got to, in a gray area here, we have to do this or do that, or I know this is important. So, yeah, that's kind of the way I have to go through it.
I can really appreciate that. I know when I was facing some challenges as a personal representative, one of the things that my attorney said to me was, um, do you want to win a long, drawn out, expensive battle, or do you want to maintain the family dynamics? And
Right.
he saved me time, he saved me money, and he saved relationships within our family, which you
Yeah.
can't put a price on that.
Yeah. I will tell you, if you get into a probate fight and it's family, one of the things I always tell everybody is, okay, if you go through with this, your family's probably going to be dead to you.
Right,
Do
right.
you want to sever all of those relationships? Because the emotion and the feelings and what will be said during the process can be hurtful to one side or the other. And depending upon which side wins and which side loses, you get kind of shut out. And
Hmm.
that's not always what people want.
Absolutely. Another question that comes to us from our Facebook community. We earlier we talked about a scenario where maybe there wasn't a will and should multiple people file to be personal representative. This question is, what happens when there is a will, but the directions are not being followed? So there's a personal representative, there's a will, and the personal representative might, like in this case, they said the PR transferred the vehicle to someone who wasn't supposed to get the vehicle.
Well, yeah, in that case, the heirs of the will, if there were, other people who benefited, they become the heirs. What they would do is file a complaint against the PR. They would go back to court and tell the judge that, okay, the PR is not following the will.
Hmm.
In fact, they're ignoring it, and they would give out examples, and the PR could be removed by the court if they find that, yes, uh, they have blatantly just ignored the will. They don't have a good reason as to why they did X instead of Y. So that would be the solution is, yeah, the heirs would bring a complaint against the PR.
Sure. And in a situation like that, if the vehicle is, in this case, if the vehicle is transferred to someone else within the family, would the court have them go back and assign it to the correct person, or is it just a done deal at that point?
Well, it's going to depend. How long ago was it? What
Mm-hmm.
was it? A bona fide blind third party that really didn't know anything about the dispute? Uh, so there's a lot of factors that go in there. The PR could be held personally liable in that case, and
Mm-hmm.
they would be obligated to pay money for the value of the property. A car would be pretty easy to say, yeah, you owe this much money, whatever you sold it for or
Right.
something. So, yeah, the PR could pick up some personal liability, by not following the will.
Absolutely. And that's another question that we had was, what advice would you give to someone who is thinking about filing pro se without an attorney? You've talked about a lot of scenarios where you've given a lot of examples of where an attorney like yourself can keep someone out of trouble and save them a lot of money. Do you have any advice for someone who is thinking about filing without an attorney?
Well, I've taken over probate from people who thought they could do it.
Yep.
Uh, it's a complicated process. I'm not saying that someone pro se couldn't do it,
Right.
but I will say they don't realize the enormity of the task they're taking on until they get into it.
Hmm.
It's like jumping into the pool. You think maybe it's only 5 feet deep and I can touch the bottom and bounce up and all like that. And you find out it's 25 feet deep and there is no bouncing up.
Right.
Uh,
Right.
so yeah, it is a big task. Everyone's different, so the complications you can get into are particular to your case. So it could be very complicated. And what I mean by that is there's going to be a lot of motion hearings over things that you're doing. An example, I've got one right now, and we've got a motion hearing over whether or not you could sever a joint title.
Mm,
That's a
mm,
separate hearing. But again, you've got to be able to go in and say, okay, this is what the law says. I have to write up a, motion briefs and all like that to support, what I'm looking for. That can get to be rather complicated because again, you've got to research the law. A, a pro se litigant usually doesn't have the background or the knowledge to know to go and do that.
right,
So
right.
they're going to be at a big disadvantage.
A huge disadvantage. And I know that some of the pro se clients that I've worked with, number one, I have a lot of probate knowledge, but I have to keep reminding them that I am not an attorney and I can't answer legal questions. And
Yeah,
they always tell me it's not a legal question, but it really seems to
yeah.
be most of the time. And then
Everything evolves into a legal question at some point, believe me. Yeah,
absolutely. And then the other piece is I will continuously offer to pair them up with an attorney so that so that they can get through this. And typically something will happen, like you said, where something will come up, they get stuck, and then they realize they probably should talk to an attorney. So
yeah,
in many cases, my pro se clients still end up working with an attorney at some point. So
yeah. It is a much better process to turn it over to an attorney, and then you don't have to worry about all of this stuff. So, yeah, as long as you've got a will and everybody gets along and things are pretty simple. And as I tell my clients, talk to your children, about what you're going to do, and that way it's not a surprise to anybody when the will comes out. Those, yeah, you may not need an attorney for those because those can go through fairly easily.
mhm.
Uh, but if a disagreement spouts up, that could start the complications, and yeah, you will probably eventually need to get an attorney.
Absolutely. Uh, and you talked a little bit about real estate, and well, you were talking about titles, and I'm applying it to real estate. One of the other questions that came up from our Facebook group was, what is the purpose of a quit claim deed if the home still has to go through probate? And I assume in Minnesota, the way that I learned it, and you're the attorney, so you could tell me if this is correct. The way I learned it in Minnesota is that if what is it? I think it's $75,000 in personal property, or if there's real estate, then you go through probate. So if
Right. If you have real estate, you have to go through probate
mm,
because again, you talk about the quitclaim deed. You've got to have a PR's deed, a personal representative's
mm,
deed, so you can't use a quitclaim deed.
mm-hmm,
Uh, so in order to sell, if there's property, if you're going to sell it or anything with it, the PR will have to do all of that, and that's all done with what's known as a PR's deed.
right, okay. If some of these families, if they sign a quit claim deed before they pass away, and the house is not in their name, then that house would not have to go through probate, right? Because it's not in their name at that point.
No, if they've transferred the property already, and there's
Yeah.
ways to do that. I talk to clients about a transfer on death deed,
Oh yes,
which
transfer
is
on death. Yeah.
which is a way to do it. But I have had some clients that they did do a quit claim deed to their children with the intent of that'll make the transfer that much easier for the kids.
Hmm.
And yeah, at that point, uh, yeah, the property's already transferred ownership, so it doesn't need to go through probate.
Okay. Yeah, so they don't give us any more details. I'm wondering if this is a situation. I've seen this too, where someone signs a quit claim deed, but then they hold on to it and they don't record it, and then they pass
Yeah,
away.
I've seen those too, and the problem you're going to run into there is that if you wait until the individual is deceased
Hmm.
under the law, that quitclaim deed's no good
Exactly.
because the person is deceased at the date of filing.
Yeah.
So yeah, you don't want to hold on to these things. You've got to file them.
Yeah. And that goes back to what we talked about earlier, making sure that you're planning with an attorney that has seen these scenarios and can help you through them.
Yeah.
Wow. There's the two sides of the coin. There's the families who learn this after it's too late, and then you just hope that they take steps to make sure they don't repeat the mistakes with their children, right?
Yeah, I know I see people like that. They come in my office all the time. And uh, yeah, the big thing is no one wants to go through probate. So they're always asking me, how can we avoid probate? And, then you dive into things with the individuals and you try to come up with a package that will help them.
Mm-hmm. Absolutely. Jerry, as we start to wrap up, are there any other important tips that you would like to leave for some of the families and personal representatives who might be listening today?
Yeah, I guess, the only thing I can leave is that uh, if you're going to do estate planning, you need to let people know where those documents are. Uh,
Mm-hmm.
you can't, the previous generation, my parents and all like that, they tended to hold things in secret. It's like, well, yeah, it's none of your business. You don't need to see any of this. Uh, I tell people you've got to share this because that will make the process easier. Uh, First of all, uh, I've had people, I don't know where the will is. I know they had one.
Mm-hmm.
I don't know if so and so went in the house before me and got it, or so you should always tell, especially who you designate as the PR, where is the original will. And that's another thing people don't understand. You can only probate an original will in this state. If you
Mm-hmm.
try to probate a copy, you're probably going to end up with a contested probate because, again, uh, the evidence is going to go back and forth as to the validity of a copy. Is that truly a reflection of what the person wanted, or so you got to guard the original will. And I always recommend put it in a safety deposit box and put your PR on there so that, upon your death, they don't have to go to court to become the PR so they can get in your safety deposit box.
Right.
That way that they have access to your will immediately. So yeah, it's those kind of things of, I would just say, yeah, let people know what you're thinking. Let at least your PR know where is the will, where the
Mm-hmm.
original is. How would they gain access to it?
And Jerry, that's a really great point. I want to go a little bit deeper into that because that happened to my family where my dad kept telling us he had a will, but he didn't want to talk about it with us. And then when we asked him where we could get a copy of the will, he kept telling us to contact his attorney. And when he finally passed, um, I shouldn't say when he did pass, and we went and contacted the attorney. The attorney said we don't keep those documents, and so
Uh,
we found it. We did find it eventually, but it took us a while. And so do you hold on to documents like that for your clients, or what?
no, I don't, and it's again with all the clients I see, the
Mm-hmm.
space I would need. Plus, I would have to keep them protected because, as I said, if anything happens to the original, well, at that point you just died intestate.
Mm-hmm.
So, yeah, I counsel people, and again, that's why I say get a safety deposit box.
Sure.
Keep that and all your other valuables in there that you need. If not that, I will say, okay, if you want to go out and buy one of these safes that you can get,
Mm-hmm. Mm-hmm.
but you got to make sure it's one that can withstand high temperatures for a long period of time. So you're going to invest quite a bit of money. Safety deposit box is cheaper.
Right.
Uh,
Absolutely.
so yeah, that's what I try to tell people, and it's like don't keep it in your desk drawer.
Right.
That's not the place for this document. But yeah, the generation, as you were talking about, that was a very common practice.
Mm-hmm.
You can't believe how many people say, "Oh, well, it's in Uncle so and so's roll top desk." and so, yeah, and it's full of stuff. You kind of know what it looks like. And so you got to go in there and sort through it and try to find, yeah, is it here? Uh, but yeah, it's just, you need to make it easy on the people who are going to be following your wishes.
Sure. Now, I've heard people mention this, but I've never asked an attorney, so I don't know. But in Minnesota, can you file a will with the probate court before you pass away so that it's on record, or do you?
Yeah, you can. In fact, I've done that. It again, the people that I've seen do it, it was like my parents' generation has done it.
Mm-hmm.
Uh, Young people, my age, the boomer generation, and everybody beyond, not so much. But I
Okay.
did a couple of them. Yeah, at that point, you file it with the court, and they microfilmed it or
Mm.
digitize it nowadays, and that way it's on record at the court. So yeah, you can do that. You can still do that.
Excellent. All right. Well, our guest today has been Jerry McDonald from the Law Office of Jerry A. McDonald in Chanhassen, Minnesota. Jerry, you shared a lot of great tips today. Where would you like people to find you for more information?
Well, you can certainly call me. My phone number is 952-253-1406. You can also go online and Google me, Law Office of Jerry A. McDonald, and my website will pop up. Uh, I've also got a website. Just a second, I'll read that off to you.
And
Have
we
to
will
look
include
on my
we'll include
card.
these in the show notes as well, Jerry. So I'll have them
Okay,
readily available.
okay. So yeah, but people can go to my website and contact me through that, or see some of the things I've done. Send me a question. Uh, and you've got my email, so if you want to put that in there,
Sure.
people can email me. I'll answer questions that way too.
Excellent. Well, Jerry McDonald, this has been very informative today. I really appreciate you sharing some insights with us, um, and when I hit the button here, we'll talk about having you come back. I'd love to have you come back another time.
Okay. Yeah, I hope we've given out some good information to people. So
Thank you, Jerry.